Court of Appeal in and for the 5th District of the State of Florida is now in session. The Honorable Rand Wallace, Judge, presiding. All persons having business before the court draw near and give attention and you will be heard. May God save the United States of America, the State of Florida, and this honorable court. Please be seated.
Good morning, and welcome to a live session of the 5th District Court of Appeal. We have one case on the docket here at 10 o'clock. It's Michael Kirby versus Stephanie Kirby. Let me introduce our panel. My name is Rand Wallace. I'm from Seminole County. Here on the panel joining me is Judge Meredith Sasso from Orange County and Judge Carrie Ann Wozniak, also from Orange County. I am going to assume, Ms. Haas, that you would like 5 minutes of rebuttal unless you tell me otherwise.
I think 3 minutes would be sufficient, Your Honor. Thank you.
Okay. All right, good morning. And yes, if the parties can just make sure, and anybody in the courtroom, that you silence any noise-making devices so it doesn't interrupt the parties in their presentation. And 3 minutes I will give you, and Ms. Haas, you may proceed when you are ready.
May it please the court, good morning. Nancy Haas on behalf of the appellant Michael Kirby, the petitioner husband in the party's dissolution of marriage case. This was a very lengthy trial court proceeding. The party's divorce was filed in 2016. It didn't proceed to trial until 2020. There are 4 issues that we've raised on appeal in this case. The first issue is the alimony issue. In this case, there are errors on the very face of the amended final judgment that was entered by the trial court judge. The trial court judge awarded the former wife $8,000 per month in permanent periodic alimony. We don't take issue with the award of permanent periodic alimony. It was a long-term marriage, and we fully understand the reasoning behind that. However, we do take issue with the amount. There was no question that by the time of the trial, the most recent financial affidavit that had been filed by Mr. Kirby reflected a gross income of approximately $21,000 per month, which included both the draws and distributions from his law firm as well as his salary. So his net was about $13,000 per month. Nonetheless, the trial court ordered him to pay $8,000 per month, which leaves him with about $5,000 per month. The interesting thing about the amended final judgment is that...
Ms. Haas, are you admitting then, for purposes of this appeal, that the net amount, not the gross amount, but the net amount on average is $13,000?
Well, I don't like to use the word average because we don't income average. At the time of the trial, his current income was $13,000 per month, and that's the only thing that the trial court could base the alimony and child support awards on, was the current income at that time.
And the final judgment does not reference the $13,000 plus for purposes of alimony. It was only acknowledged for purposes of child support. Is that correct?
That is absolutely correct. Likewise, the court uses a number to calculate child support for the former wife, took into account the $9,000 that was being paid in temporary combined alimony and child support, which was also improper, added $900 that the wife reflected that she was receiving for part-time income at the time, utilized that. But then when the court addressed alimony, said, well, I accept the testimony of the husband's vocational expert who said the wife can earn probably $35,000 a month. So it looked like the court actually imputed income to the wife, but there's no finding to that effect. So there's a lot of error on the very face of this amended final judgment, which is very problematic. The amount
if this court addressed one of those facial errors, a lack of findings, would we need to address the substance of the arguments you've raised in your initial brief?
I'd like you to address both, quite frankly.
But would it be prudent, given that any findings might change some of the substance of those decisions if the court found a different income applied to alimony rather than child support?
You know, I thought about it, and it's very interesting because there are so many facial errors, and I agree with you. So if you found that there were defects on the very face, you could remand it and send it back. But I fear because of the discrepancies as to the income amounts, as to the equitable distribution, the equalization payment, as to all of those issues, we'd have to go back and retry it, because there are so many inconsistencies and there are so many findings that are absent. I don't think at this point you can send it back and say to the judge, okay, now make findings, because you're 2 years later, to be honest with you.
So you think rather than a remand for additional findings, it would be remand for a new trial because of inconsistencies in the findings?
Well, I think that on the face of it, you could remand and say make findings. I'm not sure that in this case that would cure anything, and here's why. Because you have an award of $8,000 a month in alimony. It doesn't take into account the equalization payment. So on top of that, the other issue that we raise is that the court ordered Mr. Kirby to make an equalization payment of over $400,000. And basically said, every year you're going to take 45% of the draws from the law firm, and you're going to pay that to pay down that equalization payment. But that same draw is what is being used to pay the alimony and the child support. So it's a double dip. In addition, there was no finding that he had any ability to do that. And we know, based upon this court's own analysis and its case law, that you have to make a finding that there's an ability to make that equalization payment without subjecting the payor spouse to financial distress. And in this case...
Wasn't it 45%, though, and a minimum of $50,000 a year? Is that correct?
Compounded worse upon worse upon worse.
Okay.
Because...
But on the record, can we take what your client said to the judge on the record about the $50,000 as an admission that the $50,000 is something that's reasonable for him to comply with?
No, I don't think that
Why
was,
not?
because I don't think that wasn't a voluntary admission of, yes, I'm going to be able to pay this every year. Mr. Kirby acknowledged different things on the record. For instance, in the answer brief that was filed, they said, well, because he said he maintained the life insurance policy and didn't cancel it, that was an admission that he had the ability to continue to sustain that. I don't think that his testimony with regard to the draws from the law firm is dispositive. In fact, the trial court, in its own amended final judgment, recognized that the income was going down, that this law firm was facing challenges from firms like Morgan & Morgan, and I hate to throw them under the bus, but their name popped up a bit in this amended final judgment. So no, I don't really agree that that was an affirmative admission on the part of Mr. Kirby that he was going to have an ongoing ability to do this. And in fact, he doesn't. He can't afford to pay $8,000 a month in alimony, which we think is an egregiously high figure, and the record does not support that, as well as pay 45% of his draw. We don't know that there's going to be a draw that is going to be sufficient. And where's the $50,000 coming from? If the draw is not available to cover that, there was no finding as to where the money was going to come from to make up that difference or to even pay the $50,000. In addition, we have the issue of the attorney fee award. So on top of an egregious amount of monthly alimony and an equalization payment where there are no findings as to how he's going to be able to pay that, except based upon speculative draws in the future. And there was a lot of testimony with regard to that from Mr. Gordon and from Mr. Kirby about the amount that they needed to retain in the law firm to keep the firm running, and then it wasn't always available. And that's our
You mentioned the attorney's fees, and I'm just wondering, just based upon a simple evaluation as far as the disparity of income, don't you believe that your client should pay some attorney's fees?
Absolutely not, respectfully. During the course of the proceeding, he paid $95,000 towards the wife's temporary attorney's fees. After the payment of alimony, if he has $13,000 a month, and the court acknowledged that when it set the child support, that the income was $13,000, the net. So he's paying $8,000 a month tax-free to the wife. He has $5,000 left over. He has to make an equalization payment. He has no ability to pay attorney's fees. She's in a better position to pay attorney's fees than he is because she has $8,000 a month in alimony, plus she can make $35,000 a month from employment. And the court recognized the vocational expert's testimony in that regard. So I don't think there's any ability to pay any attorney's fees. And in addition, the law is very clear. He doesn't have to deplete his own equitable distribution award to make that. And in fact, there really wasn't cash in this case. The equalization payment, if you examine it, to the wife was based upon the value of the building that the law firm operated out of. Couldn't sell the building because they need to operate their firm. It was also based upon the valuation for the law firm itself, the business value. So you're really not talking about cash necessarily. So there was no finding that he had a savings account or retirement account anywhere to transfer that money to the wife for attorney's fees. So I would respectfully disagree, and there are no findings. There's no findings as to where that's supposed to come from. It's linked back into that equalization payment. In addition, we have...
What is your argument that the lack of findings in this context is harmless error, particularly where a certain view of the evidence could have established a net income of around $25,000?
I think that I don't think it's harmless error at all, because you're talking about $25,000, and that was a number that was thrown out in the answer brief. That was based upon child support guideline worksheet that was filed in 2017, 3 years prior to the trial in this case. There's no question that the financial affidavit that the court even relied upon in calculating child support showed no more than $13,000 per month in net income. I don't think it's harmless error when clearly in this case he does not have the ability. No savings, no retirement. He's being asked to make an equalization payment as well with no ability to pay that. And she's actually getting more of his net income than he is each month. So the court income averaged, and you can see that, I think it's on page 8 of the amended final judgment, where clearly the court says, well, between this year and this year, he made this for each year and averaged it, and then between 2017 and 2019, he made this amount, and income averaged. In this state, you cannot income average. The court cannot base an attorney fee award upon past earnings. And one of the quotes that I love from this court in the Andrews case is a quote. Andrews, I think, relying on Woodard, and it kind of sums things up. It says, past average income will not put bread on the table today. It won't. No present ability to pay $8,000 a month in alimony, no ability to make an equalization payment of $400,000, in excess of $400,000, no ability to pay attorney's fees when they were placed in the same position. She got the exact same equitable distribution he did. And they argue in their brief that, well, he bought a house, he went on trips. He used the money. They each got $154,000 during the course of the divorce proceeding when they sold the marital home. He decided to put a down payment on a house so he didn't have to pay rent. If the wife didn't do that, that was her decision. But we can't penalize him for, during the course of the case, actually obtaining a residence. And during the course of the dissolution, they did have 3 minor children that they each had time sharing with. So travel, he admitted at the trial that he went on some weekend trips, but if you look at the financial affidavit, the amount that he reflected for travel was $350 per month. So I don't think you can equate any of the arguments that they made to a finding that he had the ability to pay $125,000 in attorney's fees. And also, what's very interesting is that the trial court, in the order on the attorney's fees, found that the respondent had over-litigated the case. That's a finding in the order on the attorney's fees, found that the wife had over-litigated the case. Yet somehow, without...
I think the trial court made comment on the conduct of both parties down below. It was pretty clear that the trial court was clearly frustrated with the conduct of both of the parties. How is it not fatal to your appeal to not include the transcripts of experts Gamble, Ziegel, Jess, and any of the arguments that the parties presented to the trial court?
I think the transcripts were provided of the wife, the husband, the vocational expert, Mr. Gordon. The transcript of Gamble was not included, and that was the wife's financial expert, because her testimony was completely rejected by the trial court. If you look at the amended final judgment that was entered, there are 3 different pages in the amended final judgment where the trial court says, it declined to duplicate her analysis. That was on page 7 of the amended final judgment. Then on page 8 of the final judgment, it says, the court does not believe Ms. Gamble properly considered the contingent nature of the business. On page 9 of the amended final judgment, the court found Ms. Gamble's report to be confusing and conflicting. As such, the court engaged in its own analysis. So the court itself rejected Ms. Gamble's testimony, which is why it was not necessary for a consideration by this court. In addition, again, these errors, most of them, are on the face of the judgment. No findings as to ability to pay, no findings as to how the court calculated the income for purposes of awarding alimony, no analysis of the tax consequences, which is
Just
very...
though it's necessary in indicating whether an error on the face of the judgment is harmless or reversible, courts are required then to look to the transcript. Why is those portions of the transcript, is there any reason other than what you just mentioned, that the trial court had rejected it, that would be irrelevant to the issues on appeal?
We believe that based upon our analysis of the trial that those portions were irrelevant, and in addition, the rule provides, the transcripts, were provided to opposing party. The rules provide that if you want to obtain other parts of the transcript, you have the ability to do that.
The burden is on the appellant, though, in this court to provide a transcript that demonstrates reversible error, though.
Right, and I firmly believe that based upon the transcript that was provided, as well as the errors that are on the face, that this court can absolutely reverse this amended final judgment, which is egregious in many ways. In terms of the life insurance provision, that is the last issue that we raised on appeal. The law is very, very clear in this state that in order to award life insurance, there must be findings as to the availability, as to the cost, and as to the special needs for maintaining the policy. And I know there was an argument made, well, he said he would maintain it. No, he said that during the course of the divorce, he didn't cancel it because there was a status quo injunction order in place that didn't allow him to change any of the insurance.
He didn't provide that explanation at the trial court, though, did he?
No, he did not. But the record reflects that there was a status quo order in place and that he should not have, and he did not cancel the policy. And his statement to the court was, I wasn't going to, cancel the policy during the course of the proceedings, in the same way that he wouldn't have terminated the health insurance for his wife or his children. So despite the fact that 2 of the children emancipated during the course of the proceeding, he maintained the status quo. He did everything he was supposed to. He paid his temporary support, and there was not an issue. But again, that doesn't negate the fact that the law is very clear that there have to be specific findings in order to award or order the life insurance, that he has the ability to obtain it, that he has the ability to pay for it, and that there are special circumstances that warrant it. And I would really suggest to the court that based upon the egregious nature of the financial obligations that were imposed upon Mr. Kirby, that he certainly didn't have the financial ability to pay for that on top of paying alimony, on top of an equalization payment, as well as the order for the attorney's fees. So I think that there is a severe lack of findings in this case. And I believe that based upon the law and the law from this jurisdiction, that we're putting the former husband in a position of peril. He doesn't have the ability to pay any of these awards. And in addition, the former wife has actually been placed in a greater financial position than Mr. Kirby.
Ms. Haas, you just went south of your 3 minutes. Would you like to reserve?
Thank you. And we would just respectfully request that this honorable court reverse the amended final judgment as well as the order on attorney's fees. Thank you very much.
Okay. Ms. Haas, you have about 2 minutes and 45 seconds left, okay?
Thank you.
Good morning. My name's Elizabeth Harris, and I represent Stephanie Kirby. I'm going to just hop right on the insurance issue because I want to refer you to 2 pages in the record, 7613, followed by 7557. And if you'll bear with me, I'll just give you a quick summary of what those say. There's a conversation about the insurance, and the former husband says, he makes a remark that the policy in place is $500,000, and then, quote, that's still in existence, I wasn't going to cancel it. Then we have, subsequent to that, The trial
Ms.
judge...
Harris, does that take into account leaving the end result of the trial and all of the other financial obligations that the husband was then going to have to meet, which, I mean, they did, I believe, preserve it adequately in the motion for rehearing. Would you agree?
The issue of the insurance?
Yes.
I think someone raising that complaint is hard-pressed to complain about it when they agree to the court that we'll keep the insurance policy. Because that's what the judge says subsequent to that. I need to put these back on. He says, when this came up, the request was, should there be a life insurance policy? I said, yes, there should be. So I was prepared to hear from everyone. How much? Was that reasonable? That was foreclosed to my relief by Mr. Crutchville, who's trial counsel at the time, and Mr. Kirby, saying there's a life insurance policy. We are already maintaining it. We'll continue to maintain it. So with that being in place, I believe that Mr. Kirby cannot later complain because he's agreed to it. And the judge said, I was prepared to hear the evidence on the issue of the insurance, but you told me we didn't need to do that because you were going to maintain the policy. I don't believe now at this point that they can come in and say, well, we're objecting to the insurance policy. He's acquiesced and he said, we don't need you to hear anything, Judge. We're going to keep the policy we had in place. With respect to Ms. Gamble, I'll hop over there. I think it's important to take a very close look at what the judge says. The judge does say, I reject her need analysis. The judge says, and I apologize, I didn't write this page number down, but at the beginning of his oral pronouncement, he says, I find her competent to testify, and I don't agree with how she arrived at the valuation of the business. But, and the quote is something of this nature, like the tipsy coachman, she ended up at the same result. So he's only discounting her testimony with respect to the valuation of the business and her need analysis. There's nothing to indicate that her review of Mr. Kirby's finances was rejected. And as a matter of fact, if...
Is that portion of the transcript, though, necessary to address the issue of whether the lack of findings as to the husband's net income as to alimony is reversible error in this case?
I believe it absolutely is, because you have to conduct a harmless error analysis. And the idea that it is fundamentally erroneous on its face, that is not, to my understanding, the lack of findings have not been found to be fundamentally erroneous.
And I think that's a correct statement of the law, but in conducting the harmless error analysis here, would you agree that even on the record that we have available to us, that there is at least a range of decisions the trial court could have made on the evidence presented when determining what husband's net income was for purposes of alimony?
I'm not sure I completely answer your question, I understand your question, so I'm going to try and answer it.
Yeah, I can rephrase. So, for example, you say in the answer brief that the evidence supported a determination that net income could have been $25,000. That is one view of the evidence.
Right.
Would you agree, though, that the trial court, in its discretion, could have made a different decision on the net income based on the record we have, or do you think that is the only view of the evidence the trial court could have chosen?
I believe that when we look, because Ms. Gamble's report, it's not really a report, but her figures are in the record. When you take a look at those, she actually arrives at a number greater than that. It's about $38,000, and that could be found at 4609 of the record. She arrives at a net income of $38,310, and she then goes through a net amount and takes away the alimony and the child support and arrives at a surplus figure. So I believe that there's, while I agree that we don't have a net finding, we don't, that we don't know what the judge did because that hasn't been provided to you. So what, and I think that it's a fair question to say, why isn't it provided to you? If the challenge is to the income, the expert that was brought in to testify about the income and the need and the ability to pay, it has not been provided to you. I believe that you will find, if we had that testimony, that there's ample evidence in that portion of the transcript that was omitted to support a finding that he has the ability to pay. And I think that spills over into, because you can't do that. They can't demonstrate that they would have what does 54091 say? That there's a reasonable probability that there would be a favorable outcome to the complaining party.
Yeah, would have contributed to a different result.
I don't believe we can do that without this court knowing what Ms. Gamble says is her evaluation of what his income is, because the income surely is substantial, and it's also very important to keep in mind that Mr. Kirby's partner himself says he hasn't been working. He's not been working his cases. His income is down because he's not working, and more importantly, that the reduction in income that year was an anomaly that is frequently happens in PI cases. That testimony, it comes from his own partner. So in light of those, we pile all that together, I think the court could have relied on figures other than that $13,000, which is the last financial affidavit submitted by Mr. Kirby. And when you take a look at that too, I think it's really interesting or important to the analysis that there's a substantial increase in his expenses. So we have Mr. Kirby saying my income's going down, yet his expenses have increased almost $15,000 from the previous. Well, maybe I may be wrong. It may be more than the previous one, but within a relatively short period of time, he has a substantial increase in expenses. So given that, the court, I don't know how this court can say that there is a lack of, with the absence of the record, that this error is not harmless error. And it is their burden to demonstrate that.
So with a net income, and the net income in this case, I mean, obviously you would admit was acknowledged only for purposes of child support, correct?
Yes, sir.
But if you assume net income of a little over $13,000 and you look at an alimony award of $8,000, that 65% number, how is that not burdensome and overly burdensome? I mean, that's better than half of what the net income is.
I agree if we use the 13%, that the 8,000 is what's, I think you said 65?
65%.
You know, that is a math that's evident from, but the court crystallizes that or says, I'm only using this number for child support. Our position could be that we could have been here before you saying that figure is an incorrect figure, because we have record evidence, just looking at the documents that are in the record, that Ms. Gamble found his income to be $38,000 a month. So I think we have to keep them separate, because the court did say, I'm only using this $13,000 for child support purposes. They've not really asserted to you that was an error. They've not raised the issue of child support, and neither have we. So the figures that are used for child support purposes, I don't know that it translates into it. It does pose the problem that you've remarked on. But how do you get there without a full transcript? How do you find that Judge Roberts' failure to find a net income is harmful error without a complete transcript? And I would suggest that applies not just for Ms. Gamble's, but we don't have closing argument here. We have no idea what arguments were presented to the trial court for purposes of preserving any issues. We don't know if they agreed to a number, much like we have agreement on the part of Mr. Kirby to insurance. In my opinion, he has agreed to insurance, and he's also agreed to the equalizing payment. He has said, I think I can do that, because there's conversation prior to that about taking out a loan. And he says, I don't know if I can get a loan. I don't know about that, but when the draws come, it's usually about $150,000, $155,000. I think I can do that. I think that's an agreement to that $50,000. And with respect to that too, I think it's important to note that the statute permits lump sum payments. It permits an award of interest, which the court does not do here. And it requires that it not be so long that the party receiving the payment is not divested of the benefit of it. So here we have this payment is occurring over 8 years. I'm not familiar with any case law that says the court had to delineate where the equalizing payment was coming from. The fact is that he owes her this money. If that case law exists, I'm not aware of it, that said he had to say where it was coming from. He chose here to say the installment payment is $50,000. If you compare more from the
Well, I think the installment payment was 45% of his partner's draw and a minimum of $50,000 per year, correct?
No, I read it differently. It is a minimum of $50,000, regardless of what the draw is. So if he doesn't get enough, if he doesn't get $50,000 from the draw, it's $50,000. So for example, if the 45% of the draw was $25,000, he had to pay her another $25,000. The minimum lump.
Your position is if the partner's draw is in excess of $50,000, he doesn't owe her any more. It is capped at $50,000 per year. It's not 45% or a minimum. It's $50,000.
It's a
period.
minimum of $50,000.
It's a maximum of $50,000 too.
I see where you're coming from. I see what you're saying, and we've had some payments occur since then, so I don't want to remark on what's happening on the payments. But my reading of it is that he must pay her $50,000. That's the installment payment, and that in payment is for $408,000 over the course of 8 years with no interest. So I would suggest that. I'll probably refrain from going that far. It is not a plus in my reading of the final judgment, that it's $45,000 plus a minimum of $50,000. That's not what I read. I read a minimum of $50,000 as his payments to occur over. And the importance on that also reflects on the attorney's fees, because equitable distribution has not been effectuated here. So the reply brief makes some comment or some import to the equalization or the equitable distribution having occurred here, but she is waiting for this money for 8 years. And with respect to that, she is ordered to pay a portion of this herself. So there's a reduction in the fees. She is awarded a portion of the fees from Mr. Kirby, and she is slotted to pay the remainder. So we're not talking about a full attorney's fee award here. And that amount corresponds to what we can see from the $38,000 that I think it's fair to say the judge relied on that figure. Because you don't have we have that in the record just as well as we have other amounts on the net income. There was a.
Can I ask you a follow-up on the net income issue? If this court does reverse on the failure to make the finding on the net income, what would be your opinion as to remand, and whether the substantive issues should be addressed in the opinion, and then whether it would just be a remand for additional findings or for additional hearings?
So I was just going to remark on that, on the idea of, so we're on the same, the idea that this would require a new trial. Again, in the absence of a portion of this record, for you to make a decision that the lack of findings was erroneous on its face, to suggest that we then have to remand this for an entirely new trial when you don't know what's in a portion, in a substantial portion, because there was some dispute. We're in disagreement as to even the length of days of this trial, but the final judgment says 5 days. So Ms. Gamble testified for a lengthy period of time. That's missing. To suggest that we need to go back for an entirely new trial and bring all these experts back in when you can't make that harmless error determination, I don't believe that is warranted here. I would suggest that if the court were to say you need to come in and make new findings as to the net income, that it would be based on the evidence here, because there's no suggestion that there's some fundamental problem with this testimony or this underlying. There's no challenge to the value of the business. There's no challenge, actually, that the the equalizing payment, the sum itself is incorrect. There's this assertion that he's not able to pay it, not that she's not owed it. And the idea that she is owed that is not challenged. The record shows that she's owed $400, even if we take out the attorney's fees, $308,000 is what the equalizing payment is. How that would all get unwound by a net income amount that's missing from this final judgment, I don't see how that's supported here. If you don't have any further questions.
I'll ask you one more on the harmless error.
Okay.
So if we view the role of findings as both to make a factual finding in the case, but to allow for appellate review of the issues, how would a lack of finding not be harmful error when there's competing views of the evidence? Well, let me ask it this way. If we had a complete record and there was competing views of what a net income could be as to alimony, and the trial court still failed to make the finding, would it be harmful error in that case?
I believe that as long as there is evidence in the record to support, like by way of analogy, if we were looking at any of the alimony factors, if there was record evidence of any of those factors in the transcripts, I would believe that the court could, even if it's by dispute, this court could say, well, the court is permitted to believe that and permitted to accept that. I think the same thing would happen here. If the net income figures, and there are quite a number in the record, if you look at all the financial affidavits and you look at what Ms. Gamble did, there are significant. And I do think it is significant that we have testimony that this 1 year that is substantially less than what historically Mr. Kirby's been earning is an anomaly. I think that is significant, and the court could and very well may have, because we don't have Ms. Gamble's testimony. I've never seen it, so I can't tell you that the court didn't consider all of that in her testimony, or herself dealt with that testimony that this was an anomaly year, where he suggests that 1 year he is unable to, or lacks the ability to pay. I don't think the court can make that determination based on what you have before you.
Mm-hmm. So in other words, if there's competent substantial evidence to support what the trial court did, regardless of whether there could have been competing views, then it would be harmless error in this case.
I think if we had a transcript, mm-hmm. and you were able to read Ms. Gamble testify that she believes, based on her analysis and explaining her analysis, that $38,000 is his net monthly income, that is competent substantial evidence, which could have supported a finding of ability to pay.
That's all I had. Thank you.
May it please the court, I'm going to try to be very succinct. This whole issue of Ms. Gamble's testimony is a complete red herring. And it's a red herring because the court repeatedly asserted in the final judgment that it was discounting all of her testimony with regard to the valuation and with regard to everything else. There's not one statement in the amended final judgment that says the court accepts Ms. Gamble's testimony. And quite frankly, if it's not in the amended final judgment, it doesn't matter. So that's my issue. And to say that...
So I think another principle that we have to apply is that we operate under the assumption that the trial court did not err as an appellate court. Closing arguments are included. What if there's a concession of some sort in the closing argument, for example?
Closing arguments are not evidence.
But concessions, parties and courts can rely on concessions. So,
okay.
So for example, if that is something that happened, we don't know whether that happened, would a concession effect on harmless error analysis in this case.
You know why we know it didn't happen? Because as Judge Wallace wisely said, we had a motion for rehearing filed. And the motion for rehearing that was filed by the husband raised all of the issues that he was going to assert. So we know from the motion for rehearing that there were no concessions on those issues. So when you examine that, that really answers your question. And in addition, the idea that this year was an anomaly, no. If you look at page 10 of the amended final judgment, it lists the husband's income as the court found it to be from 2012 to 2019. There are income figures in that list that are even lower than this alleged anomaly. It was an anomaly. Mr. Kirby testified that during the course of the parties' divorce case, the number of cases being taken in by the law firm kept decreasing, and his partner, Mr. Gordon, said the same thing. In fact, by the time of the trial, it was 50% of what it had been the year before. So there are no anomalies. There was ample testimony in the record that provided that showed that the business was declining and that there was no anomaly. In addition, there was a statement made, we don't know what the judge did. Yes, we know what the judge did. What the judge did is contained in the amended final judgment, and that's what we have to look at and consider here in deciding whether the trial court erred. And there's no question. There's no analysis as to the income. There's no way for us to figure out what the alimony is based upon at all. There's no income figure that said this is the figure the court's using. It doesn't exist. So it's not harmless error. There's egregious error. In addition, with regard to competing views on income, it doesn't matter. We have a final judgment where the court failed to make those findings, and we know under the applicable law and the statute that those findings are necessitated. So again, I would submit that the court erred egregiously in not making those findings and ordering an amount of alimony that was far in excess of Mr. Kirby's ability to pay, no ability to pay the equalization payment, and in addition, that the amended final judgment lacked the findings that were necessary to support the life insurance. Thank you very much.
Thank you, counsel. It was a well-argued case, and we're adjourned.
Thank you.